Hello, everybody. The May 14th, 2026 CPRB meeting is called to order at 6:07 p.m. We will now go into the roll call, beginning with Victor. Julia.
Here.
Lanny. And Mr. Mark. Warren Hamilton presiding. I am also here. Next up, I would like to, if you've all reviewed it, which I'm sure you have, someone offer a motion for approval of our prior minutes or current minutes. Motion by Victor. Is there a second?
I'll second.
It has been second. Is there any discussion on the minutes, updates, changes? Hearing none, and we already have the second in there. Can I get a call of those in favor?
Aye.
Everybody affirmed. Aye, myself. That has carried. Next, we are going to enter our public comment period if we have anybody.
There are no public commenters this evening.
No public comments for this evening. So we will go on to communication from the City of Albany. Updates. No?
Oh, Mr. Himmler, I'm sorry. Would you like to make a comment? Come around and sit down at the rostrum.
So thank you, and just please state your name.
Good evening, everyone. My name is Himmler Francois. And public comment. I'm not going to keep it long, knowing that I already spoke with administrative staff and who introduced me with the new detectives on board. But the purpose I came for this evening was to follow up on a case that was back in 2022. I came here several times before. It was different board members, but I was told it was being worked on, but till today I still have not heard anything. I wanted to make sure that it wasn't one of the cases that end up falling at the waistline, because at the end of the day, it is a bit hard to go from being a homeless vet and suffering through the mishandling of police officers that are not fulfilling their duties in the way in which they sworn to do. So, as I stated, I'm not gonna keep it long, but what I will do instead is share for the record a copy of what the statement that I brought in with me this evening. That way you guys could have it and maybe help me bring closure to this case. Because too many of us are there struggling to do right, and then right is not done by us. And thank you for your time.
Thank you. Appreciate your time for coming out.
All right.
Next, we're going to have communication from Updates Program Director Schaff.
Good evening, everyone. And so first I want to give you an update on the number of complaints that are currently pending. The CPRB and APD currently have 165 open complaints. 45 of those 165 complaints are pending action from the police department. 120 of those complaints are pending action by this body. 9 of those 120 complaints will be reviewed at this meeting. 1 of the complaints will be closed at this meeting without review. 17 of the complaints are under the 120-day time limit. All of the other remaining complaints are beyond the 120-day statutory review period. And a decision from members is pending on how to address those complaints. Last month, I remind you, I provided you updates to the survey that was conducted, and the results of that survey overwhelmingly appeared to be in favor of reaching a disposition on those complaints and focusing solely on timely work. In addition to that, when you received your confidential materials for this meeting, I provided you two informational memos, one related to our Facebook account and one related to requests for proposals for mediation services. After this meeting is over, sometime this week or next week, I will make the requests from the Corporation Counsel's Office related to both the Facebook account and the RFP for mediation services, so we can get those issues resolved. As a reminder, currently the CPRB has 2 Facebook pages. One of those Facebook pages is controlled by the current CPRB staff and was created in the latter half of last year. The other CPRB page is controlled by former members who have declined to provide the needed access for that page. And in regards to the request for proposal for mediation services, there were some irregularities with the procurement process for the mediation providers in 2025. So we are going to go forward with the RFP process to help address those irregularities and prevent them from reoccurring. Additionally, we have received requests and we are actively working on developing community learning sessions for this board to put out into the community with our various community partners. Now that we have some additional support staff, we can begin working on those programs. The current timeline I'm working on those events are going to be the latter half of July or into August. That'll give us time to find a space, secure time and date, publicize, and build out the materials. My intent with these learning sessions is it's not going to be just the CPRB. The purpose of the CPRB being there will be to provide the community information on how to access our services, what our services are, our powers and authorities and abilities are. But I also intend to extend an invitation to our counterparts at OPS so they can come and participate and provide the community an insight into how the OPS process works when they're conducting their investigations as well. Chances are there will be multiples of these events. As I said, we're in the very early planning stages. I also want to give you an update on our staffing. 2 weeks ago, we had our first new staff member join us, and that was Ms. Braylin Cordonas, who's sitting here to my right. I'll give her a moment here to introduce herself. As she settles into her role, I'm also going to begin the process of setting up to interview our 2 investigators to fill our 2 investigative roles. My goal for filling those 2 roles is by the end of July. So if everything goes to plan by the end of July, the board will be fully staffed, which will be the first time the board has been fully staffed in more than 18 months, if not 24 months. I have no other updates. Do the members have any questions?
No, I don't have any questions.
Can you hear me?
Yes.
You brought up about the investigators. It's going to be 2 new investigators. Have we hired them yet, or?
No. So remember, we discussed last month. Last month, we discussed the request for proposal responses for Ms. Schwartz and her team at T&M and 2 other firms.
Okay.
That is one process. We also are budgeted to have staff that are employees of the city as investigators for the office. That's what I'm speaking about tonight. We've received applications. We posted all 3 roles, so the confidential secretary role and both investigator roles at the same time, and I got applications all at the same time, but I wanted to fill the confidential secretary role first. So now that she is in place and getting situated, we can work towards filling the 2 investigator roles, because the ultimate goal is to in-house all of the investigative work into city operations for both financial reasons and for speed and access reasons.
Okay, thank you.
All right, Braylin, if you want to introduce yourself.
Thank you, Garrett. My name is Braylin Cordonas, and like Garrett mentioned, I'm the new confidential secretary. And so it's an honor to be here, and I'm looking forward to working alongside everybody. Thank you.
Thank you. Welcome. Next up, we have our old business, which is officer nominations, and we will either nominate or postpone. So I open it up to members to offer their perspective.
I would vote to postpone until we at least. Can you hear me? So I would like to postpone until that time, until we get the other two staffs, because we're pretty close to that.
Are you speaking of additional board members or
Yes.
additional? So,
Yes.
okay.
This-
So you are correct. The Common Council is working towards filling their 4 vacant seats. I'll give you an update on that real fast. Currently, they have advanced, so 2 weeks ago, they did interviews with 7 candidates, and they advanced 1 of those 7 candidates. The remaining 6 candidates are still under consideration. They will be doing interviews with at least 2 additional candidates on Wednesday next week. And the hope is that after they interview those 2 additional candidates, they will be able to select out of those 8 possible candidates, 3 additional members to proceed, or 3 additional candidates to proceed through the appointment process. There is currently 1 individual proceeding through the appointment process. My understanding is her background is complete or is almost complete. Once that is done, it'll be reviewed by the Public Safety Committee, and if they determine there are no issues, she will be presented to the entire council for a vote. She is on track to be potentially seated and vote eligible by our June meeting, and then the other 3 seats are on track to potentially be filled by our July meeting.
Okay, thank you. So I'll just like to postpone until that point.
So was that a discussion piece or a formal motion? All right, anybody else got any thoughts on that?
Say it again, Mark. We didn't.
With waiting. Julia, you know I want to hear from you because you made a motion, I think, last time. I'm good. I don't need to speak, and I'm not sure if we do need a formal motion. Okay. So I guess since it's an action, we need a motion. Anybody second that motion?
I second.
After a second, we normally would have discussion. We kind of had it already, but is there any discussion on that motion that was seconded? Hearing no further questions, can I call a vote on that? All those in favor? Can you say aye? Aye.
Aye.
The motion has carried. All in favor. There is no dedicated new business, so next up is the review of our complaints. And that begins with Member Hamilton, and that would be me. So,
You skipped over the updates from OPS, sir.
I didn't see that it wasn't on the agenda. I'm sorry.
It's agenda item H1,
H1.
and complaint reviews are
Oh,
agenda
my-
item H2.
Oh, yes, that is true. So, review of complaints, it starts off with report from the Office of Professional Standards. Sorry about that.
There's no problem, and there's no offense taken on that. I'll
Okay,
keep this
thanks.
brief as far as updates go. I have some 2026 stats for the board and the public. In 2026, we've already opened 26 new cases as of today, and we've closed 66 cases. So the office is very busy. As you know, our office also handles some other administrative functions within the police department, one of those being the background checks and hiring of all APD employees. We're just finishing up a intensive hiring cycle, and we are happy to say we'll be welcoming 21 new police officers that will be getting sworn in at the end of the month. I think I should also probably take a second to address the public comment from the gentleman that was here. From speaking to him before, he did have some concerns about the status of his complaint, and he was under the impression that it had fallen through the cracks and possibly wasn't investigated or completed at all. So I took the time to reassure him that as far as EPD goes, we are separate from the CPRB. The CPRB is our, more or less our oversight body. APD has no backlog of complaints. So his complaint was closed by our office. However, explaining to him the difference between what APD does versus what the CPRB does, it's possible that that case was not reviewed by this body, but it was closed by our office. So I will take the time tomorrow to review that complaint and get him some updates on the disposition of that case. And anyone else in the public or anyone that shows up to our meetings that has those concerns, I just want them to be reassured that their cases are being handled in a timely manner, and whether or not the CPRB has the jurisdiction past the 180 days, we will get them information in regards to their complaints and the status of those complaints. That is all I have for updates.
Thank you. Does any of the members have any questions or comments? Appears not. Thank you.
So we want to have public comment if the members wish. After you look at the amendment, we will take the meeting. We're currently
So we're going to continue with the complaint review. I have the first complaint, that is CC 2025-003. The complaint is that on January 20th, 25, while picking up my wife from work, already parked at my destination, Officer Felton got behind my vehicle and put his lights on. From the moment he left his car to approach mine, he was very aggressive, starting with demanding my back windows be rolled down before he got out. The weather was extremely cold and my 11-year-old son was in my vehicle. I stated this to Officer Felton along with the fact my driver's window was down as he began approaching. Once at my driver's window, Officer Felton was very aggressive and nasty with me, to the point where I asked for his sergeant and was repeatedly told no, and that he didn't have to produce him because he was on the radio, and I gave Officer Felton my license like he had asked. The complainant goes on. He still proceeded to treat me this way after continuously being denied to see his supervisor and giving Officer Felton the document he requested from me. I began to roll up my window, assuming he'd take it to his vehicle like a normal officer would. But instead, he immediately opened my car door. Officer Felton then stated multiple times that this is going to get bad for you, and understand what's about to happen. Our officers are here to protect, but at this very moment, I felt like my life was in danger. Still, at this moment, I had never been told the reason he got behind me after I already parked. After the threats, Officer Felton reached into my vehicle and unbuckled my seatbelt, grabbed my right, and pulled me out of my vehicle. Once out my vehicle, he twisted my arm and stated, why are you being so effing extra?" as he applied the handcuffs extremely tight, leaving indents in both my wrists. I stated to him that he's using excessive force when I'm being compliant and not resisting, as I stood uncuffed, or in cuffs, I'm not sure, feeling threatened and treated unhumanly. My 11-year-old son sat in my car traumatized. Since this event, he has had many nightmares and speaks of it daily. I feel like my rights were violated for what was supposedly a traffic stop. Not to mention 2 more patrol cars arriving on scene as if the officer was in danger when I was the one being violated. When the assisting officer was explaining the tickets given to me, Officer Felton got back out of his vehicle and started to approach me saying, "Why don't you get in your effing car and leave?" When he got back to his vehicle, he yelled out, "I'll see you later," which is clearly a form of threat. I feel very uncomfortable knowing someone like this serves our people. That was the complaint form. Upon review, the complaint report, my summary of the investigation. On January 1st, 2025, the complainant allegedly caused a traffic infraction by crossing a double solid yellow line to drive around a car that was sitting at a green light too long. This traffic infraction was observed by the officer who made a U-turn to pursue the complainant's car. The officer caught up with the car, which had pulled into a parking lot. As the officer pulled up closer to the car, he became concerned about the tent on the car window. To help ensure his safety, he announced on the patrol car external speaker that the driver should let down the windows. The driver would not comply to open all windows and only rolled down the driver's side window down halfway so that he could give the officer his license. It sounds like the officer was the first to use profanity as he approached the car. The driver did present a New York State license, which the officer reached for and grabbed in a normal manner. At that point, the complainant immediately rolled up his window. The officer then immediately opened the door. I wanted to know whether the officer had the legal right to open the door for 2 reasons. 1, I did not think under normal circumstances that would be okay. And 2, because it really made the complainant emphatic that the officer called his sergeant ASAP. I checked with the detective on this case, and I revisited the body-worn camera footage again to make sure I understood what the Detective Burns, explained to me versus what I was looking at with my own eyes in terms of someone not being an officer looking at the video. This question was not part of the investigation, meaning I had the question of why did they not say, why did this officer open the door? But that was not part of the formal investigation. That's why I had to reach out to the detective beforehand to ask that question, because it's not appropriate to ask him on the spot here. So I did have enough time. But I was puzzled that it was not part of the formal investigation. The question was not part of the investigation because the OPS review of the body-worn camera determined that the windows did in fact have a tent, that the officer said he felt he was unsafe approaching, given, as he said, the totality of the circumstances, and that officer announced before he got out of his car that the windows should be lowered. The officer said in his interview that he opened the door to de-escalate the situation, such as him having to break the window or the driver pulling off once he rolled up the window, and because of the tent and the concern about his safety. The driver's response repeatedly was that it was too cold with his son in the car making such a request. The officer had no way of knowing that a child was in the car. The driver's hands are in his lap when the first frames of the camera appear into the car after the officer opened the door, and that is when his emphatic and incessant request for a sergeant can be first be heard. After the door opened, the level and intensity of the scene got bad verbally. Unfortunately, the officer intermittently used profanity a few times while talking to the complainant. The complainant did not want to comply with the request to present his registration and instead said all he must do is present his license. The officer let the driver know that things were not going to go well based on how he is complying and that he will shortly be removed from the car. The backup officer had arrived, and when the officer started the process of removal, the driver quickly complied by getting up on his own and getting out of the vehicle. The officers did not physically remove him from the car. After talking more between the complainant and multiple officers in more foul language and some reasoning and negotiating, Officer 1 handed the detained individual to Officer 2 so that Officer 1 could go and run the license and write the tickets. The officer found that the license that was presented was not valid, and that resulted in a lot more discussion and conversation among the parties. The officers decided that he would let the female with the valid driver's license drive, and the complainant had to sit in the car and they needed to drive off. My overall assessment is that the driver did not have the inclination to peaceably comply with the commands or requests by the officer. The complainant repeatedly said that his civil rights were being violated and that the officer had threatened to pull him out of the car and throw him on the ground. The body-worn camera shows that the officer told him that if he had to remove him from the car, that he would be taken to the ground. It was a cold winter day. The officer started the verbal squabbling right from the start when he approached the car after his request to lower the windows were repeatedly ignored. The driver immediately snaps back and the tense scene begins. It is unfortunate that it happened in both directions. It reminds me of one of the important aspects of this board's work, that part of our responsibility is to help increase relations between the police and the public, to perform community outreach and to hold police accountable for their actions. Completing these reports is just one part of our incredibly important mission. This type of case gives us an example of topics and scenarios that the CPRB can discuss with the individuals when we do outreach in the community, as well as when our members meet in the meeting rooms with APD management and leadership. My findings are that I concur with OPS findings and make the following recommendation. Those findings are, for Officer Felton, conduct standards, 1, aggression and nasty were sustained. The other charge or allegation was use of force, excessive force, and that was exonerated. I agree with both of those. 1, the language, the officer clearly was using bad language. Exonerated on excessive force because the officers did not remove him from the car. My recommendation for policy, officers should lose a leave credit. Is there any discussion or questions on this report? Well, I look for a motion.
You need to first check and see if the complainant wishes to make a comment or if they're in the room.
Is the complainant here for this case? They are not. So I want to, if there are no questions from any of the members, well, can I get a motion to either approve or not approve my report?
For process purposes, the presenting member should make the motion, and then another member should second.
Okay. Well, I move or motion that you all accept my report. Can I get a second?
Second.
Second by Victor. All those in favor by saying aye. Lonnie? Yep. All in favor? The motion, the report has been approved. Next up, I think is Julie. I got to go back to the top of my report. Oh, it is Victor. Okay, next up is Victor.
Good evening. This is a complaint review CC 2025-029, received May 28th, 2025. OPS detective sign was Detective Burns. Picked the person as the signed member to this complaint. It was submitted May 28th, 2025. The incident took place on May 27th, 2025. The incident took place at Dudley Heights, Albany, New York. There was an allegation of misconduct regarding Detective Lyles and Cialis, an allegation of forced entry into this individual's apartment, and the call handling by individual that was within that apartment of someone who was claiming they were nude, and the call handling was damage and search. Upon my investigation, revealed that AB Detective sought and obtained a no-knock search warrant that was executed at the complaint's residence. Upon entering the residence, detectives encountered a new male in the kitchen near narcotics and narcotics paraphernalia. The detective also encountered the complainant who repeatedly stated she was naked from within a closed room. Detective Lyles asked the complainant to put clothes on, but the complainant did not respond. Detective Lyles requested assistance, and Detective Silas assisted him. At that time, both detectives, Lyles and Silas, entered the room, provided the complainant with a robe and clothing. Once the clothing was searched, APD detective completed this search and arrested the male for narcotics possession. There was no sign of damage to the property. Other than related entry, and the complaint informed OPS that there was no damage caused to the property, just as things were moved around. I concur with the OPS findings, and I make the following recommendations. Officers, allegation of misconduct. Detective Lau, which the allegation of forced entry was improper, which is exonerated due to they didn't have a no-knock warrant. The call handling, the individual was detained and nude, which was unfounded, as I reviewed the video, and the call handling and damage search was no finding. Okay. And the OPS report was, this was exonerated by OPS, call handling, detained nude, unfounded by OPS, call handling, damage and search was no finding. Recommendation was for policy and discipline in connection with sustained allegation, if there was any. That's it. Does everyone approve of it?
So Victor is motioning that we approve his report.
Is the complainant present regarding this? No? Thank you. Okay.
Second by Mark. All those in favor? Aye. That motion has carried. Next up, we have CC 2025-065, Member Morris.
Good afternoon. This is review of complaint CC 2025-065. It was received by the office on November 28th, 2025. And it was assigned to OPS Detective Stiles, and the CCRB reviewing member was myself, Member Morris. This complaint was made by a father on behalf of a juvenile son. The father alleged that there was an improper search, and the review of records reflects that Officer Dudley, which was the officer, was responding to a call of a group of juveniles fighting and shots being fired, and that the complainant was released when witnesses did not identify him as being involved in the incident which resulted in that call. Social media footage was reviewed, and it was shown, which was taken by a bystander, which shows Officer Dudley arrived at the location, and a group, including complainant, had already been stopped by additional officers. Officer Dudley did assist in patting down the complainant's son, and does then ask for this individual's information. The complainant's son did not provide the information, and instead questioned why, at which point Officer Dudley threatened to take the complainant's son downtown if he would not provide his name and place him in a police vehicle. The complainant's son then complied, and Officer Dudley explained why he had been stopped and the pat down had occurred. Video footage does show that this was not the only individual who was stopped, patted down, or placed in a police vehicle. Based on the nature of the call, Officer Dudley is permitted to conduct a pat-down search and to ask for ID. However, it was felt that he could have answered the individual's questions and did not need to threaten to take him downtown. Nevertheless, OPS finding were that this be closed as ineffective policy or training. I concur with those findings, and I also concur with the actions that have been taken, which was Officer Dudley was spoken to about having better communication. I will make a motion. If the complainant is here, I ask that he or she make themselves known. Seeing that they are not, I will make a motion that we accept the findings of CC 2025-065.
Seconded by Victor. All those in favor say aye. Aye. That carried all members.
And I believe I have,
Yes, you are next.
which is CC 2025-067. This is a complaint which was received on December 9th, 2025, and it was assigned to Detective Adelon, and the reviewing member was myself, Member Morris. The complainant the location of the incident was 43 New Scotland Avenue, and this occurred on December 5th, 2025 at 15:04 hours, so 3:04 in the morning. The complaint was of call handling, a failure to take a report, and OPS's finding was that it was exonerated. My review of records included the APB building surveillance footage, officer statements, as well as the call report, and Albany medical records were not available because a subpoena is required for them. The review shows that the complainant does go into the lobby of APD headquarters and appears to be holding his neck. He appears to have a normal conversation with Officer Morris and did not appear otherwise injured in any way. He indicated he wished to file a complaint against Albany Medical Center Hospital for an assault, which he alleged had occurred in the 15 minutes prior. Officer Morris determined that given the shortness of the time period elapsed, the incident would be best handled by investigating officers responding to the scene, and at that point created a ticket for officers to respond to Albany Medical Center area. Officer Morris provided this information to the complainant, and Officer Hooper recalled observing the ticket in the system and in anticipation of being assigned to that call, did speak with AMCH, Albany Medical Center Hospital Security, who informed him that the complainant was a known person to them and that they had to remove him from their triage area on that day. There was no force alleged to have been used other than a hand to escort him out of the building, and Officer Hooper then relayed this information to Officer Bowen, who was working at the center station desk. When complainant went into that building at 16:38 hours, he again requested that his complaint be filed against Albany Medical Center, and Officer Bowen, with the information he had received from Officer Hooper, informed the complainant the incident did not meet the threshold for an assault charge and provided him with a victim rights form at 17:03 hours, as well as instructions as to how he could complain using AMC Hospital's HR. Based off this record, I concur with OPS's findings and concur that this should be closed as exonerated for failure to take a report. Is the complainant present and wish to speak? Hearing that there is no complainant present, I make a motion that CCRB 2025 be closed as exonerated for Officers Morris, Hooper, and Bowen.
I'll second that. We'll call the roll on that. All those in favor say aye.
Aye.
That has carried. Next up is CC 2025-74, Member Hamilton. That is myself. The complaint is that on December 22nd, 25, Everett, Washington, the allegations are that Mr. Washington alleges Detective Roche, hopefully I said that right, made her son say he shot himself. document, and those preliminary findings is recommendation that this investigation be closed as follows. Call handling exonerated where the acts which prove the basis for the complaint occurred, but the review shows that such acts were proper. My review of the complaint shows that on November 26, 25, police were called to 275 Colony Street Apartments because of shots fired. When the police arrived, they walked up to the second floor landing of an apartment building and found a young black male lying on the ground on his side or back. There was a lot of blood visible on the man's hip and thigh area, as well as on the ground. He was not showing pain until he was asked to move his leg so the police could search for a bullet wound. They then applied a tourniquet, and the man immediately felt a lot of pain and thereafter was incessant that the tourniquet be removed ASAP. The detective began taking the formal statement at his computer in the office, in contrast to the day before with the more formal discussion that happened at his house in the living room in front of his mother. So after the initial scene, the detectives or officers went to the house. So about 8 minutes into the interrogation in the office, the man indicated in his statement that he was on his way to an apartment at 275 Colony Street and that unexpectedly he was shot on a walking path. In the actual body-worn camera video that shows him on the ground having a tourniquet applied, I heard an officer referring to a bullet casing. If that casing was found on the upper ledge, he could not have been shot on the path below. He then says that he did not see anything, just heard shots, and did not think he was hit until about 10 seconds later when he felt a hot spot on his thigh. He says just after they heard the gunshots and his friend said he saw someone in red that could have been a shooter, he did not see anything and says he did not see anyone. He only thought the gunshots came from behind him. The investigation also found or discovered the following. Mr. Washington's mom filed a complaint, and in part, she questioned why APD did not check Mr. Washington for gunpowder on his hands if they felt...
Member Hamilton, if I can just remind you that we try not to use the complainants or civilians involved in our investigative reviews names during this process to maintain the necessary confidentiality.
Okay, I thought that might have been removed from the report if that was the case, but...
When you're reading the report, when you write your report, you can use their names in writing the report, but when you're presenting the materials to the public, we do
Okay.
not want to identify the complainants if possible.
Thank you, thank you. All righty. As of December, the complainant's mom filed a complaint. She questioned why the APD did not check for gunpowder if they felt he shot himself. Even early into his interview on 12/10/25, the complainant's mom, well, the individual again states that he was shot by someone else. As of December 10th, 25, at the December 10th, 2025 interview, the individual looked and talked lucid and soberly and answered directly that he heard 3 shots. He clearly states that he first realized he was shot when he felt hot at the entry location about 10 to 15 seconds after he heard the shots. He later clarifies that the friend did see someone in red and that he did not say that the person was the one who fired the shots. 34 minutes in, the detective goes to print a preliminary victim witness statement for the man to sign. When the officer returned, he again said that his friend called the police as soon as they got into the apartment. The detective returned and offered the statement to the individual to review, and he was warned about making false statements. He signed the statement. Thereupon, immediately, the detective shifted gears and then read him his rights immediately. Detective Roche read him his rights, and the individual confirmed that he understood his rights. He agreed to keep talking without counsel present. This happens 41 minutes into the interview interrogation. The man never exercised his right to plead the fifth or the right to counsel. The detective did not remind him or bring it up again, but proceeded to talk to the individual. The detective then disclosed 2 pieces of evidence, one about the approximate location of the shooting called The Cut. The Cut is a known pathway or trail in the apartment area. And according to the detective, the man never went through the cut at that time. The second disclosure was that there were some questions about whether they called APD as soon as they got into the house. The detective then told him that a shell casing was found right where he was lying on the ground outside the apartment, and again made it clear that if the investigation shows that the statements were false, that he could be arrested. Detective Roach said he did not want to arrest and charge him, and that all he wanted was the truth. He is again reminding him that he can stick to his prior statement that was written and signed, or in a way that will better, or he can stick to his prior statements or change it in a way that better fit the video evidence, the forensics, and possible witness statements. This does not seem like a coerced confession, but then again, I am no expert on the subject. The detective then just keeps saying that he wants the truth. He also lets him know that the forensics indicate that the wound happened to the front of his thigh, yet he said the sound came from behind him. This indicates he thought he was shot from behind. 52 minutes in, the individual decides to alter his story. He now stops saying he was shot below in the cut area, but instead he was standing outside the apartment, already on the landing, smoking some weed. It is there that he then heard some shooting, thereby still claiming he was shot by someone else. The detective then says, which is it? Did you get shot near the cut or standing up here on the landing? This shatters the reliability of the prior written, signed statement of the events. Just over 1 hour in, the detective is still trying to build trust while also giving the individual more possible facts and forensics of the case to make it clear that it is evident that the signed statement may not be accurate if the detective was giving him accurate information. He now lets the individual know that no muzzle flashes were seen on any surveillance cameras at the location down in the cut. The detective says that there may be video that shows his friend running away from the scene after the shots were fired and returning before the police arrived. The detective asked why his friend would leave him if he just got shot, and was he removing evidence from the scene. The detective then speculated that the individual prints may be on that shell casing. In the complaint, the individual's mom said that he was maybe on medication, and for that reason the statement was coerced in some way. The individual repeatedly said, in fact, that he was never really in pain except for the tourniquet, so he did not seem to be doped up on meds. The detective also starts to appeal to his reason by highlighting the possibility of there still being a shooter and a gun out there, as opposed to the possibility that he may have been handling a gun and it accidentally going off. Detective Roach wants him to consider his actions, the gravity of the situation, including the amount of possible evidence against him, and to weigh that against his written statement. The detective wanted to build more trust and rapport, so he brought up a few areas in the statement that were true, such as the fact that the individual was shot and that there was blood in the apartment that indicates that part of the story was correct. However, the detective made it very clear that he thought the statements were largely false, so the interview interrogation continued. The findings that came out were that the call handling and the core statement was exonerated. And I concur with that recommendation from the police, OPD. And I recommend that if the individual is present, they can speak, complainant or mom, which they're not here. So I'm making a motion that CC 2025-074 be approved.
Second.
Second by Victor. All those in favor say aye. Aye. Everybody say aye. That motion carried. Next.
I believe it's me. I have CC 2025-075. This is a complaint received on December 20th, 2025. And the assigned detective was Detective Stiles. The date and time of incident was December 28th, 2025, and the location was a personal residence on First Street. The complaint was of a improper or illegal search. The complainant alleged that officers entered his apartment without a warrant to search for his uncle, and OPS closed this matter as ineffective policy or training. However, based upon my review of the findings, I did find that there were records and body-worn camera footage that reflect that officers were responding to a call of a screaming female within indifferent residence on First Street. And when they arrived to that location, they were led into the building by a man with a dog, who they later came to determine was a suspect for the assault. However, that individual had been allowed to leave the location. And so when bystanders on the scene informed officers that that suspect stayed in a nearby home on First Street, the officers went to that location. The door was unlocked, so they entered. And then once inside, they were approached by males to whom the officers explained that they were looking for the suspect. And when questioned about the search warrant, the officer stated that the matter was permitted under exigent circumstances. However, the officers are incorrect. There were no exigent circumstances present. They ultimately were counseled and retrained on circumstances by which they may search without a warrant and what best practices are regarding when individuals should be allowed to leave the scene. I did not concur with OPS's findings, and I actually found that this matter should be closed as sustained because there appears to have been a misunderstanding of the applicable law and policy, but a review shows there is sufficient evidence to prove that an improper search was conducted at the location on the date, and therefore I feel that this complaint should be closed as sustained. I do agree and concur with the proposed action of counseling and retraining the officers. If the complainant is present, there is opportunity for them to speak. There does not appear to be anyone present who wishes to speak. If any members have questions, I'm happy to answer them. Does anyone have any questions for me? Okay.
Why don't we do that after the motion? Because that way,
Okay. Then I will make a motion that this complaint be closed as sustained, rather than ineffective policy or training.
One moment.
Second.
One moment. Member Morris, were you asking if your fellow members had questions?
I did ask, yes.
So discussion and questions about the complaint probably should occur before the motion is made, because if sufficient questions arise to table this complaint for a future meeting, that will change the nature of the motion. So the procedure for complaint review should be the presenting member presents the complaint, details what their recommended findings are, affords the complainant an opportunity to speak if present, opens the floor for discussion amongst members, and then makes a motion for the approval.
okay, well, the reason I said that is because I guess with Robert's rules, you normally discuss after the motion. So this is a procedure outside of the normal Robert's.
The discussion is not about the motion. The discussion is about what was learned during the course of the complaint review. If the motion is made to approve the findings and members disagree, you can not second that motion, or you can make a new motion to table the conversation. But opening the floor for fellow members to discuss the complaint is intended to ensure members are aware of all of the information before you make a motion to resolve the complaint.
Okay, that makes sense. Thank you.
Do you have any questions that you wanted to ask?
I did have some questions, and I was able to reach out because I want people to understand that I thought it was a little odd to say ineffective training, et cetera, but maybe you got more insight into that it's more of when an officer might do some action that's intentional versus not intentional. So I do concur. I had some questions, but I think I'm okay with it right now. And I do like how you change it to sustain, because it probably could have went either way. Was there a second? Oh, you're still, there's more questions?
So I can answer based off of the board's recommendation, and I think either Lieutenant Peterson or Commander Riddy will be best to answer on APD's behalf. Membership is empowered to request from the assigned detective the history of the officer. So if you have an officer or you're reviewing a complaint where you are concerned that this is a repeat pattern or a continual aspects of misconduct from one individual officer, you can request that the assigned detective share you their complaint history and the outcomes of those complaints. Typically, from an administrative investigative standpoint, the prior acts, whether they're sustained or prior allegations, regardless of their outcomes, should not impact the ultimate recommendation on finding. However, if it is a sustained finding, it can influence disciplinary recommendations. In regard to Member Hamilton's question about the recommended finding from OPS, the findings that are available are codified into law. Section 42-345 of city law specifically states that ineffective policy or training is to be used when the matter does not involve guilt or lack thereof, but rather ineffective departmental policy or training to address the situation. That's the specific definition of that finding.
That definition is?
It's codified into the law that governs this board. It's section 42-345 of city law. It's also written in many documents that you have access to as a board member. And I added, at the request of Member Morris, I added it to the member report template in a footnote, so going forward, all of your member reports will have all of the finding options listed in a footnote with the legal definitions.
Gary, you got a lot of experience with this stuff. I'm currently working as a compliance officer somewhere, and through OASAS and oversight, a policy is effective based upon how it's written and whether or not it meets the criteria or references the right stuff. So, and that's partly where I had the problem. So if there are a bunch of rules and regs here and Member Hamilton never follows them, it doesn't mean your policy isn't effective. It just means I chose not to follow it. And that's kind of where, and it's maybe semantics, but that's where I was getting to, where the effectiveness of the policy is not determined by who follows it.
Correct, but when members are selecting finding recommendations, they need to select the recommendation that they believe the evidence supports, and that definition needs to be supported by law. I do not disagree with Member Morris's assessment in this instance. I believe her recommendation to recommend a sustained finding was probably more applicable than effective policy or training. However, the finding recommendations are the sole purview of board membership. So board staff is here to support and provide guidance as necessary. So staff will not supplant our opinions for the recommendations that you make, but we are here to be a sounding board, or you can ask for guidance or feedback or input, and we will gladly offer that to you. We will also be a resource for policies and procedures and proper aspects of work. I think we'll let Lieutenant Peterson or Commander Riddy talk about your question regarding how OPS considers the history of an officer when completing an investigation. I
don't want to leave that quite yet because, and I know you said it came from the law, but in my opinion, that part of the law, the content, that phrasing is not accurate.
Okay, Mr. Hamilton, I read you the law as it is written. The law says ineffective policy or training is defined, essentially, where the matter does not involve guilt or lack thereof, but rather ineffective departmental policy or training to address the situation. So, my understanding of this, and Member Morris can correct me if she perceives it to be a different way, my understanding of that definition is ineffective policy or training should be an instance where there is a department policy that does not clearly cover the issue, or training does not clearly cover the issue, or an instance in which department policy and training are in conflict with each other, or an instance in which policy says one thing but command staff issues directives in opposition to policy, because that creates a conflict.
That was my impression, and that's why I recommended that that not be the finding, because in this case, there is policy that's applicable, and it was just the officer misunderstood it. Hence why I felt that it should be sustained rather than ineffective policy.
Okay.
Would you like an answer from APD regarding the officer's history question?
You said you were sending it over to them for something else. So I'm done with my questioning.
Okay.
Hello, board members. For anyone, for the minutes and all that, Commander John Riddy with the Albany Police Department, Office of Professional Standards. Your question is in relation if an officer's history is taken into account in the complaint process, as far as her findings go, correct? Am I correct? So, no. Short answer is no. The complaints and the actions of the officer need to stand alone individually for each complaint as they are received. The only time when an officer's prior conduct, or prior complaint allegations or anything that comes in is taken into consideration when it comes into like discipline, anything like that. So if there are several cases of sustained as far as rudeness, that comes into factor. You know, there can be a time and a place where it might result in oral counseling or written counseling or whatever. There becomes a point where that is no longer effective. You can't continually orally counsel someone, say, hey, you're being rude, hey, you're being rude, hey, you're being rude. It needs to move up the chain. Much like this, in a case much like this, regardless of what the findings are from the board or OPS, ultimately the decision was that CPRB agreed that the officer should receive more training. Now, if the officer were to go out and do that same act again, now we are now moving our way up the chain. We've already trained you on it. Now we need to take that into consideration and be like, okay, is the fact pattern the same, which you've already been trained for? That we can no longer fall back that you need training on that. Now it needs to move the chain. So that's the only time that previous complaints or actions or whatever really come into play. An officer's conduct and the complaint that's lodged against them kind of need to stand alone on their own, and that's the only time we review prior incidents with the officer. No problem. Any other questions before I go down? No?
Thank you for that. So we will continue. Next, we have.
Hold on. I don't know if we have voted on.
Oh, we didn't vote on it?
Not yet.
Oh, I'm sorry. I'm getting
So-
ahead of myself.
At this time, I'd like to renew my motion that we change, or that we recommend that the matter CC 2025-075 be closed as sustained rather than ineffective training or policy. Do I have a second?
Second.
All in favor?
Aye.
So then this one is now moved.
Thank you very much.
I don't have the next one.
You don't have the next one. Next is CC 2026-007, and that's Member Jones. Your button.
Okay, there we go. Case number CC 2026-007. The complaint was received on February 19th, 2026. The initial incident took place January 7th, 2025 at 14:45 hours. Let's see. I will briefly summarize this, given the nature, but in essence, the complainant made a complaint that, and it was passed on, and files and information was provided to APD. The complaint was not found to be a APD issue rather than a fire department matter. The complaint reported that the police department did nothing wrong. Therefore, I concur on this with OPS findings and make the following recommendation. There are no findings. So I move that we accept this as closed with no findings. Anyone have any questions?
And the complainant does not appear to be here.
And the com-
Is there a second to the motion?
I'll second.
All those in favor say aye. Any
Aye.
opposed? None abstained? Aye, motion carries. Next, we have CC 2026-013. That's Member Jones.
Yes, thank you. On this matter, repeating the case number, CC 2026013. The complaint was received on March 10th, 2026, and the, we don't have a date that, anyways, it was, the detective assigned was Stiles. And I have been a lucky member as I've been assigned things to learn the process, and that this incident, again, in essence, the complainant revealed that the assigned detective who responded to the complaint, they did not want to speak with the detective any longer about the matter. Therefore, the complaint appears to be related to more of a domestic matter. It was more of a domestic matter having to do with family members and a complaint of a family member. And then the complainant said, you know, I no longer want to discuss the matter with ABPD. Therefore, I concur with OPS findings and make the following recommendation. No finding. Any comment on this?
The complainant does not appear to be present.
Thank you. And in that matter, then I move that we accept the findings as presented by OPS, that this has been closed and there are no findings.
I second that motion.
Thank you.
All those in favor say aye.
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 Motion has carried. Last member, Morris for CC 2025-049.
Thank you. Complaint CC 2025-049 was received by the office on September 17th, 2025. The assigned OPS detective was Detective Burns. This complaint was submitted on September 17th, 2025, about an incident that occurred on September 6th, 2025, on a corner of Ontario Street and Hudson Avenue. And the allegation was use of force for the discharge of OC or pepper spray. The OPS finding was that this matter be closed as exonerated. And after review of the body worn footage, as well as records of the incident, I concur. Basically what occurred was officers were trying to disperse a large group of individuals who were on the public sidewalks on Hudson Avenue between Phil and Ontario. They gave multiple officers, as well as using whistles, they gave multiple directions that the sidewalk be cleared as they approached the corner, and the complainant was not dispersing despite these directives. They approached the complainant while giving additional directives that he move, and they also indicated that he would be pepper sprayed if he did not comply. At that point, the complainant reached out his arm to redirect one of the horses, which was being ridden by an officer, and Officer Fitzgerald did use OC spray on complainant. Based on the complaint's disobeying of verbal commands, and the officer's use of force was not unreasonable, and it is in compliance with the department policy. So I concur with OPS finding and make the recommendation that this matter also be closed as exonerated. Is there any public comment from the complainant? There's not. Do any of the other board members have questions?
I do not.
In that case, I move that we accept the findings of the OPS and close this matter as exonerated.
Is there a second?
Second.
Tie goes to Lonnie or Ms. Jones, Member Jones.
All in favor?
There's probably no discussion because we already had it, so all in favor?
Aye.
The motion has carried. We have closure without review for CC 2026-012. It's withdrawn. I offer a motion that we accept that. Can I get a second?
I'll second.
And all those in favor of withdrawing that complaint, say aye.
Aye.
Aye. We did have a individual come in, I guess, later, so I'm pretty sure we would definitely want him to speak if he wants to. So we will offer up this opportunity if the gentleman still wants to speak before us.
You'll need to make a motion, second, and vote to reopen public comment.
I will make a motion that we reopen public comment to let the individual who arrived after we closed it an opportunity to speak.
I second it.
All those in favor say aye.
Aye.
Aye. It has carried. We will listen.
He doesn't actually have a comment, he just wants a status update on his complaint, so I will take care of that.
In that case, I move that we close the public comment.
All those in favor, closing public comment, say aye.
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 Aye. Can I get a motion to adjourn?
I'll second.
Can I get a motion?
Oh, I'll make a motion that we adjourn the meeting for May 14, 2026.
And I will second that. All those in favor? Say aye.
Aye.
Any opposed, abstain? Motion carries. Thank you, and
Thank you.
thank you.